you very much. Can you hear me? So we all know that there is a spectre stalking Europe and Britain, the spectre of the phobia. And we've heard from previous panellists about the combined forces of HR and EDI, Equality, Diversity, Inclusion, which is what I call an empire of inclusivity that is being built across the workplace, telling everyone at work all the different ways in which they may like to consider themselves victims of oppression. And so what we see is discrimination at work appearing on the landscape of the employment world as a huge, gross, systemic problem. HR sector studies will tell us for 2025 that 45% of UK adults have faced discrimination at work. 69% of ethnic minority employees face or have faced or experienced racial discrimination in the workplace. And according to the Don't Divide Us report, the Equality Act isn't working. We know the outcome of this industrial complex of EDI. We're seeing rises in employment tribunals under the auspices of discrimination law. We're seeing rises to the extent that I think for 2016 to 2024, the report notes some 250,000 discrimination tribunals before the employment tribunal. Now, I just want to say something as an employment lawyer about the way it actually works on the ground from the claimant's perspective, who is bringing an anti-discrimination claim in the employment tribunal. There are 7 ways, I think, in which we can say that the employment tribunal is claimant friendly, much of which has to do with the Equality Act itself, but also to do with the EDI industrial complex. First of all you need to do to file a discrimination claim is scribble on a bit of paper, "Me is discriminated," and that will get the ball rolling. You don't really need to have sophisticated particulars of claim. These can be worked out along the way. Once you've lodged a claim, off it goes, and you can have 100 million preliminary hearings where kindly judges, often working with litigants in person, will help the claimant to understand the nature of their own discrimination and identify the points at law that they wish to bring before the tribunal. So you don't really need to have a good claim. The costs in employment tribunals are borne by each side, so you don't have to worry about the other side's costs in general. So that is an incentive to claimants, but it's also a pain in the neck for employers who will have to pay out for legal costs in claims often stretching over years, whether or not the claim against them is ill-founded or not. And of course, therefore, employers are incentivized in this way to settle with claimants, and they frequently do. Even if the claim against them is spurious, they will meet claims with settlement propositions. The time limits for bringing a discrimination claim are 3 months, which is not very long time at all, but the Equality Act allows the tribunal a discretion to extend time for discrimination claims if the tribunal finds that to do so is just and equitable. To strike out a discrimination claim is incredibly difficult. Even if a claim has almost no prospects of success in the minds of a judge, it is very difficult to strike it out initially because there is a lot of case authority and policy that advises against doing anything like that until a discrimination case has been heard fully on the facts, which, as we've just heard, takes years sometimes with lots of hearings. Tests for discrimination are worded in such a way, particularly in respect of harassment, but even direct discrimination under the Equality Act, so that almost any act, gesture, word, comment, throwaway remark could be construed as somehow creating a negative or hostile environment for an employee or unfavourable treatment of some kind. And so it's very easy for somebody who has a grievance of some kind to construct a case of discrimination or harassment around some sort of protected characteristic. We know that there are codified protected characteristics in the Equality Act, and they seem to be straightforward, I think, but they're not. But anyway, they are evolving and mutating as we speak. And so there isn't just the protected characteristics that we see in the Equality Act, there are derivative protected characteristics as well. It's a moving beast. The burden of proof moves to an employer in the employment tribunal once the claimant has established that there are some facts on which discrimination might have taken place. Then the burden of proof is on the employer to show that they have not acted in a discriminatory way. So what this shows is that there is a huge incentive for people, employees, to bring claims against their employers. It is to the credit of our judges and our system that many of these claims do not succeed finally, but that is of little comfort to the taxpayer who is funding the whole process, very little comfort to the employer who is becoming increasingly vulnerable to expensive litigation. And what I would like to end with, because my time is short, but I can elaborate on aspects of the Equality Act that are moving and driving the DIE industrial complex, such as the public sector equality duty and the paragraphs on positive action. We can talk about those later if people are interested. But what I would like to end with is a question to you, which is, if we have gross discrimination against people of all kinds based on their protected characteristics in the workplace, why then do we not see this gross number of discrimination claims in the county courts? We simply don't see it in those numbers outside of the workplace. For example, in the provision of goods and services, why, if we live in a racist society, do we not see racism in every shop, hotel and other service provider in the country? What we see is this in the workplace. That tells us something. It tells us that the workplace is becoming a kind of laboratory, a legal laboratory for engineering ideas about oppression and grievance culture that are being workshopped in the workplace and then taken to tribunals. And I think that the comparison of the county courts with the employment tribunal tells us that there's something going on here. But what it is and why it's happening, I'm going to leave to the audience to work out for themselves. Thank you very much.
Thank you.